Jurisdictional choices, maritime actions. An understanding of the choices to be made as to appropriate jurisdiction for maritime action depends, to some extent, upon some comprehension of the development of the law from foundation of the colony of NSW to the present day. It is desirable, therefore, to traverse this ground first. The commission issued to Governor Phillip, the first governor of New South Wales, included provision for a court of vice admiralty. This court was established and functioned with various changes from time to time. The other Australian colonies also established vice admiralty court as they came into existence. In 1890, the Colonial Court of Admiralty Act 1890 was enacted. It provided that every court in a British possession having unlimited civil jurisdiction for the time being so declared should be a court of admiralty. Those courts should have jurisdiction over the like person, matters, and things as the admiralty jurisdiction of the High Court in England. The transition from Vice Admiralty Court to Colonial Court of Admiralty came into force in Queensland, South Australia, Tasmania, and Western Australia on 1 July 1891, and in New South Wales and Victoria on 1 July 1911. From this source, therefore, the Supreme Court of the state derived their jurisdiction thereafter in admiralty matters. With federation came further changes. In the Australian Constitution, the Commonwealth Parliament was granted power to make laws to confer on the High Court inter alia, admiralty and maritime jurisdiction, to define the jurisdiction of any federal court other than the High Court, and to invest any court of a state with federal jurisdiction. There are other constitutional sources of power for maritime action. The Commonwealth Parliament has invested the state court with federal jurisdiction in all matters in which the High Court had jurisdiction or in which original jurisdiction could be conferred on it. Thus, the High Court and the State Court had two sources of jurisdiction. Until the Admiralty Act 1988 came into effect on 1 January 1989, the Court of Competent Jurisdiction for Action in Rain were the High Court, the Supreme Court of the State, and the Supreme Court of the Northern Territory. There was an argument that the Federal Court may have had jurisdiction, but it was not tested. Admiralty Act 1988. The Australian Law Reform Commission produced an excellent research paper on Australian Admiralty jurisdiction in November 1984 and a report on civil Admiralty jurisdiction in 1986. The report recommended a bill and rules which became the Admiralty Act 1988 and the Admiralty Rules or Statutory Rules 1988 number 269. By this legislation, the civil maritime jurisdiction was substantially altered. It has become the main source of civil maritime jurisdiction in Australia, repealing the Colonial Court of Admiralty Act 1890, except for proceeding then on foot. It should be borne in mind that the Act isn't necessary for an ordinary action in personam based on common law or statutory right, personal injury caused during water skiing in Moreton Bay. The Act confers jurisdiction on the Federal Court, and the courts of the territories and the court of the state are invested with federal jurisdiction in respect of proceeding commenced in personam for a maritime claim or for damage done to a ship. Action in rain involving the arrest of a ship or cargo and action for limitation proceeding are restricted to the Federal and the Supreme Court, although there is power for the Governor-General to proclaim other court to have jurisdiction in rain. The jurisdiction extends to matters associated with matters in which the court have expressed jurisdiction. Being a Commonwealth Act where no request and consent jurisdiction has been reversed by the state, no attempt is made to confer or invest jurisdiction in a matter not of a kind mentioned in Section 76 or Section 77 of the Constitution. Action in rem against a ship or property may only be commenced as provided by the Act. Such action may relate to a proprietary maritime claim or a general maritime claim. A proprietary maritime claim relates to possession, title, ownership, or mortgage of a ship, or a share in it, or a claim between co-owners relating to it, mortgage of the ship freight, or a claim for satisfaction or enforcement of a judgment against a ship or other property in proceeding in rem. A general maritime claim relates to a claim for damage done by a ship, collision or otherwise, liability arising under the Protection of the Sea Civil Liability Act 1981 or the equivalent state act, oil pollution, loss of life or personal injury, an act or omission of owner or charterer or their servant or agents relating to loading or unloading, or embarkation or disembarkation or carriage of goods or person, a claim relating to charter parties, salvage, general average, towage, pilotage, goods, materials, or services supplied, construction, alteration, repair, or equipping, liability for port, harbor, or canal, and etc. Fees, a levy, disbursement, insurance, wakes, arbitral award, or interest. A distinction is made between a proprietary maritime claim and a general maritime claim because in the latter case the proceeding is only competent when, in relation to the ship or other property, usually cargo, the same person must have been the owner or charterer or in possession or control of the ship or property when the cause of action arose and the owner of it when the proceeding is commenced. So, if there is not the ownership protection connection, the claimant may not proceed in rem for general maritime claims but is restricted to proceeding in personam. This means that the ship or property may not be arrested, but of course there is still the jurisdiction in the court to hear the action. Other than the claim just described, action in rem may be commenced for maritime lien, salvage, damage done by a ship, wakes, master disbursement, or other charge. Also, any maritime claim, general or proprietary concerning a ship, but not cargo or etc., may be commenced in rem if the same person was owner, charterer, or in possession or control when the cause of action arose and was the demised charterer when the proceeding were commenced. This is a similar limitation to that on a general maritime claim, which is not surprising as a demised charterer is regarded as the owner for many purposes. The Act is predominantly procedural in that it mainly seeks to codify the law and clarify the appropriate court and procedures. However, it does create some new law. It extends the right of relief to enable arrest of surrogate or sister ship if, in relation to a general maritime claim, the same person was the owner or charterer or in possession or control of the first ship when the cause of action arose and was the owner of the second arrested ship when the proceeding is commenced. It should be noted that the claimant can only arrest one ship at a time in relation to a claim, and the rearrest of a ship or other property is only allowable by order of the court. Under the Act, service and arrest is permissible at any place within Australia, including within the limit of the territorial sea, but not ship or cargo in them. When exercising a right of innocent passage, the Service and Execution of Process Act 1901 doesn't apply. The Admiralty rules cover service and many other procedural aspects. The schedule to the rules has a very useful set of forms for use in proceeding under the Act. When the Act was passed, the International Convention relating to the limitation of the liability of owners of seagoing ships 1957 and the 1979 Protocol were given effect. By the Limitation of Liability for Maritime Claims Act 1989, the Act is amended and the 1976 Convention is given force, although this latter Act hasn't yet been proclaimed. Thank you.